Hi everyone, and welcome to today's webinar, EU and UK Product Compliance, What's Hot in 2025 and Beyond. So as always, just a little bit of orientation about the webinar platform before I introduce our speakers for today. The webinar slides are available to the left side of your screen, along with a few helpful links if you would like to explore and learn more about compliance and risks and how we can simplify and accelerate your compliance processes. We want this webinar to be as engaging as possible, so please send us any questions you may have and we'll aim to address them during the Q&A session at the end of the webinar. If you would like to submit a question for this Q&A session, use the Ask a Question widget on the left side of your screen. And for any questions that we don't get to today during the live session, we'll follow up directly with you. At any time, if you're interested in a member of our team follow up with you directly, aside from asking a question, please don't hesitate to use the Start a Conversation button at the bottom of your screen. And last but not least, the webinar recording will be made available to you within 24 hours. So my name is Orla Morris, and I'm the Content Marketing Manager here at Compliance and Risks. And I'm delighted to be joined by the wonderful Ed Turtle, who's Associate at Cooley, Jamie Humphreys, Special Counsel at Cooley, and Jack Eastwood, an Associate at Cooley. So Ed is a Senior Associate in Cooley's products team with well over a decade of experience in product compliance and liability issues. Dual qualified in England and Wales and Ireland, Ed assists clients with product issues arising in the EU and UK. He also regularly acts as coordinating products counsel on international mandates and has handled matters across 140 countries since joining Cooley. Ed's regulatory practice spans the technology, life sciences, and automotive sectors, and he is a recognized specialist in disruptive technologies, for example, AI, AR, VR, and online platforms, product liability, and class actions. Ed is a well-known thought leader in the product space and has been elected to serve as an officer of the Products Committee of the International Bar Association, Vice Chair of the International SLG of DRI's Product Liability Forum, and a member of the International Association of Defence Counsel. Ed lectures on EU product compliance and liability laws at the Academy of European Laws, the leading centre for excellence in EU law, established by the European Commission. Ed is also regularly sought out for his views on product compliance and liability issues, including by publications such as the New York Times, Wall Street Journal, and Financial Times. Thank you so much for joining us today, Ed. We're also joined by Jamie Humphreys, who is Special Counsel in Cooley's product team. He advises clients at all stages of the product lifecycle, providing advice in relation to international litigation and regulatory matters. He is often called on to work on global recalls and internal investigations arising from product safety issues across multiple sectors. This includes handling the largest investigations by the UK's product safety regulator, the Office for Product Safety and Standards. He helps clients navigate their compliance with novel product safety and liability laws and has acted on some of the most significant product liability matters in the UK. Jamie frequently writes and speaks on product safety and liability matters and trains the next generation of product safety professionals on the Business Certificate of Competence in Product Safety, the UK's only accredited product safety course. Thanks for joining us, Jamie.
Hi, everyone.
And last but certainly not least, Jack Eastwood is an associate in Cooley's product team. He covers the nexus of UK and European Union sustainability and product law matters and is deeply integrated into Cooley's US practice, giving him a unique insight into the interactions of international regimes and related sensitivities. He has extensive experience advising global companies spanning a broad range of sectors with a specific focus on life sciences and technology companies. Jack regularly works with UK and US public and private companies, helping them navigate their UK and international sustainability reporting obligations, climate-related targets and disclosures, due diligence, and supply chain transparency requirements. Thank you, Jack, for joining us today. So before we kick off the webinar, I would like to provide a background about compliance and risks for those who are joining us for the first time. At Compliance and Risks, our mission is to help ensure global companies have the tools and information to build safe, sustainable products in a world full of change. We are the trusted product compliance technology provider for the world's leading brands and have spent 2 decades honing the digital tools, expertise, and content you need to stay ahead of the dynamic regulatory landscape, proving your product compliance, protecting your brands, and helping to drive your growth. We have the world's most comprehensive regulatory database with over 100,000 regulations historically available in C2P. With a global regulatory coverage and expertise across over 10 industries, we understand that regulatory compliance definitely doesn't sleep. Our regulatory experts team is truly global, with 28 languages collectively spoken across the team, all fortified by our 13 knowledge partners. As mentioned, C2P is our enterprise SME-led software, the key to unlocking market access as new products can be designed and built with confidence that you've met all compliance obligations. And this involves keeping on top of regulatory changes and their impact worldwide, early warning alerts, impact probability, productivity workflow tools, and so much more. And with that, I'm delighted to finally hand it over to you, Jamie.
Thanks, Orla. Hi, everyone. It's great to be here today talking about the latest products and ESG laws. So it's been a busy time for EU legislators, and we're going to give you a flavour of some recent changes, as well as changes on the horizon in 2025. We'll discuss some of the key drivers for those changes, including the expectation of increased enforcement by regulators. And we're going to take a deep dive into new EU legislation across safety, liability, and consumer rights. We're going to look at some of the changes in the UK in the consumer rights sphere and the proposals for changes to product safety rules. And finally, we'll touch on key ESG developments. If you've got any questions, please feel free to drop them in the chat, and we'll answer them if we've got time, or otherwise we can come back to you separately. So to set the scene, this is a really busy slide with 36 initiatives relevant to products and ESG that have been introduced in the EU since 2019. We're going to talk about the drivers behind these new initiatives in a few slides, but for now it's important to note that this is an unprecedented wave of change, and it's going to be transformative for the products world. It's a really significant upgrade across product compliance, safety, liability, and consumer law. And keeping up with these rules is a full-time job, let alone implementing the changes needed to bring companies into compliance. And this is what we have coming down the track in 2025. We'll talk about a few of these in a little bit more detail, but you'll see that there are still some legislative changes that are coming, but more and more what we're seeing now is move to the implementation stage with the introduction of secondary legislation guidance. And now it's not enough to dive into all these changes, so we've cherry-picked a few that we'll be talking about later on. But before we do that, we wanted to give a little bit of context in why we're seeing these changes now. So there are a range of global organisations which have been looking to grapple with the sort of updates to products and ESG laws. The OECD, the UN, the European Commission, and the Organisation of American States are just a number of the organisations that have been putting together working parties, developing policy around these areas. Now, there are 4 key drivers that we see for these sorts of changes: new technologies, heightened consumer awareness, e-commerce, and climate change. In terms of new technologies, IoT and AI-powered devices keep products regulators up at night, and their introduction in an increasingly digital world has been a key factor in the development of many new laws. It's driven by concerns that the existing laws were not fit for purpose. So one concern was that the definition of product was too narrow and only caught software in very limited circumstances, which would mean that a lot of new technologies that are being developed just wouldn't be legislated for. So these are some of the changes that have been introduced to address that concern. In terms of heightened consumer awareness, consumers are a lot more engaged nowadays. They're aware of key issues. They're very vocal about it, often via social media. And there are a new suite of consumer laws that are giving consumers the ability to hold businesses to account, whether via their consumer rights or increasingly via group actions. In terms of e-commerce, over the past 25 years, the internet has grown exponentially, and e-commerce has developed at a pace to create the giants of the world economy. Regulators have been concerned that the legal framework has not matched this progress and isn't fit for purpose. The safety of products sold online has been an important feature of the new changes and is a key focus of the UK Product Safety Regulator, the OPSS, as they push through the UK's Product Regulation and Metrology Bill through Parliament, which we'll touch on later on. And of course, climate change. Many of the new products laws have focused on increasing the sustainability of products, whether through the right to repair initiatives or effective energy labelling and disposal. So the environmental impact of products is a key driver for these changes, and we'll talk about that in more detail later. And finally, it's just worth flagging that the current US administration has been gunning for products laws in a lot of its trade negotiations. There's been a lot of talk about non-tariff barriers to trade, which raise the cost of doing business for companies. A lot of this has been articulated in press reports and sort of the reports we're seeing out of the UK and EU, where issues around safety are absolutely sacrosanct. But it's obviously a real time of flux internationally and politically, and so we'll just have to wait and see exactly how these things pan out. So an important consequence of the new laws that are being introduced is that there's increased focus on enforcement. Regulators are being given more powers to enforce with stronger sanctions. In some cases, a fixed percentage of global turnover, and that can act as a really strong deterrent. But if sanctions are never imposed, then the laws lose their power over time. And the message we're receiving is that this won't happen this time with these new laws. We're seeing the creation of more specialised regulators. So in the UK, the OPSS was created in 2018. The AI Act is creating a new suite of AI regulators across Europe. Dialogue between regulators is also increasing, whether informal or formalised via memorandums of understanding. Regulators are speaking to their colleagues across the world to develop an understanding of global risks posed by products. Consumers are being given the tools to take action, whether reporting into SafetyGate under the new GPSR, or taking action against non-compliant products as part of a representative action. And of course, social media enables consumers to raise complaints vocally. And of course, expectations are also changing. So new products with novel risks are often held to much higher standards of safety than existing products that are objectively more dangerous. For example, AI is being regulated before its risks are fully known. By contrast, the Product Liability Directive was only introduced after the thalidomide tragedy in the 1970s. And with that whistle-stop tour, I'll hand over to Ed, who's going to talk about some of the key changes in the EU product space.
Thanks very much, Jamie. So yes, I want to speak for a few minutes about some key current and upcoming initiatives in EU product regulation. Bearing in mind those slightly terrifying slides that Jamie has just shown us, showing the significant volume of legislative change we're seeing in Europe. This is a topic that could keep us here for some hours, but I think I only have about 15 or 20 minutes, so I'm going to try and keep things pretty snappy. So first up, I wanted to touch on the continued focus on regulating new technologies. There's no doubt that regulating tech products, and particularly emerging tech, remains a hot topic and very much a policy priority in Europe. So a couple of examples of this trend on the slide here include the Cyber Resilience Act, or CRA, and the AI Act. So picking up first on the CRA, which typifies this trend. CRA is the new sort of comprehensive product cybersecurity regime coming to Europe. By way of background, some of you may be aware that the cybersecurity of tech products sold in the EU has been an area of policy concern for some time. Back in 2022, European policymakers made some adjustments under the Radio Equipment Directive, commonly known as RED, to include new cybersecurity requirements via delegated act. And as you may know, RED establishes a regulatory framework for radio equipment, which includes a wide variety of devices that use Wi-Fi or Bluetooth technologies. So those new requirements included mandatory safeguards for preventing network harm, misuse and fraud, and protecting privacy. That was a fairly significant change at the time because for the first time, cybersecurity considerations were formally becoming part of the conformity assessment procedure. And that applied to many consumer technology products because of the prevalence of those Wi-Fi and Bluetooth technologies. We're finally going to see enforcement begin in August this year of that RED Delegated Act. It's been pushed out a number of times due to complications around the standards that were developed in association with it. So it's been worth being aware of that. But at the same time, I should also mention that this is very much a stopgap solution designed to address a perceived problem around cybersecurity in the short term, pending a more comprehensive legislative solution, and that solution is the CRA. So the CRA will establish new cybersecurity obligations for manufacturers of connected devices, and they will be required to design, develop, and produce products in a way that ensures an appropriate level of cybersecurity. And one of the reasons I flagged this area of reform as a sort of hot topic is because of its very broad scope. So I think the expectation amongst stakeholders, we were closely involved in the legislative process, and the expectation amongst most stakeholders was, until recently, that the CRA would apply in the context of software to the extent it applied to software in a fairly narrow fashion, largely to software associated with hardware, bearing in mind that the RED DA is very specifically focused at hardware. So software like companion apps might be caught, but standalone software would not generally. That's not what's transpiring, at least at Commission level. And what we're seeing is the Commission taking a position whereby there's a much broader scope for the CRA. Their view is that the CRA should apply to all hardware and most software products, including operating systems, word processing software, games, and most mobile apps. So we're seeing a significant increase in the potential scope and significance of the CRA within the software context. So that's one area of development, one hot topic within this new technology theme. The other is, of course, the AI Act. I'll say a quick word about this, probably one of the best known examples of the EU's current focus on new technologies, very much a world's first in terms of this horizontal regulation of AI as a new technology. I think is often thought of as a groundbreaking piece of new legislation. And whilst I do agree that it's groundbreaking in many ways, it's not really new because, like the CRA, it borrows a lot of concepts from established EU frameworks, primarily the data privacy framework, chiefly GDPR, and secondly, and tied closely together with that, it borrows a lot of concepts from the existing product compliance framework, the framework that was designed to apply to hardware products until now. That's helpful in some ways because it leans heavily on established products concepts, including things like conformity assessment and CE marking, harmonized standards, the definitions of operators, manufacturer, importer, etc., the triggers for obligations, including the concept of placing on the market, procedures for corrective actions, etc., etc. So on the one hand, it is very much a sort of development of existing EU laws. On the other hand, these laws were very much developed with a view to regulating hardware, and the application of these laws to AI systems is something new and very much untested. For those of you who are not familiar with the AI Act, it takes a risk-based approach to regulating AI systems. At the top, you have of the sort of risk-based pyramid, you have prohibited AI systems, which pose unacceptable risks and are banned outright. Beneath that, you have high-risk systems, which are subject to the most onerous obligations under the Act. Then you have limited risk systems, which are just subject to certain transparency obligations. And finally, at the bottom of my sort of fictional pyramid, you have minimal risk systems, which are subject to very limited obligations at all. AI Act also introduces guardrails for general purpose AI. It's testament to both how quickly the technology is moving and how difficult it was for legislators to grapple with the technology that the original Commission draft had no provision at all for general purpose AI. So that's how fast things have moved. There's certainly not time for me to give a comprehensive overview of the AI Act today. So I just wanted to sort of zoom in on one area that's becoming hot right now. And that's because there's a potential extension to what products could be categorized as high risk. So for those of you who've had to grapple with the AI Act already, there are two routes to high risk categorization, remembering that this is important because it brings you into the most onerous obligation territory. So first, there are certain AI systems which are high risk by default, and that's decided by purpose of the system. So if AI system is used in an area like biometrics or educational or vocational training, you can go into the high risk territory by default. Secondly, AI systems can be considered high risk where they perform a safety function and the product is required to undergo mandatory third-party conformity assessment. Under EU product compliance laws, those laws are identified in an annex and include things like RED and medical devices legislation. The industry expectation around that second limb, and I would say the proper interpretation of that provision, is that it should only apply where a third-party mandatory conformity assessment was mandatory for the product in question. But that's not the position that we're seeing being taken by the Commission, who we are seeing in certain expert groups, and now in the preamble to the new toy safety regulation, take the position that products which are subject to a regime where mandatory third-party conformity assessment can be necessary, even if it's not necessary for the product in question, would be brought within scope of this second provision. That's a very significant extension of how this could apply, and it's certainly something that's worth watching, because I think many stakeholders who, on a preliminary assessment, thought they'd be out of scope, could find themselves being brought back in by virtue of that, simply if they have products that are subject to RED or medical devices legislation or any of the other regimes that are identified in the annex. So just something to pick up on there. I also wanted, sticking with the theme for the moment of this continued focus on regulating new technologies, to pick up on two examples of EU reforms that have been sort of made in the name of regulating new technologies, but in practice have had a much broader impact. The first of those, which has been hard to get away from in the last 6 months, is of course the General Product Safety Regulation, GPSR, which started to apply in December. So a quick update on that. Many of you will be familiar with this regime. It's the overarching product safety framework in Europe, the legislation that the Commission likes to call it safety net. It applies to virtually all products that are placed on the EU market, to the extent that sector legislation doesn't introduce more specific requirements. So essentially, it acts as a base layer, which can be topped up by more targeted legislation. It's the first reform of this regime in nearly 25 years, so it's quite a significant change, and it's very ambitious in its scope, with a whole host of new requirements that affect every stage of bringing a product to market, advertising it, and taking steps in market where issues arise. A number of those new requirements are very much focused on new technologies within the ambit of change, such as considering the impact of software updates as part of a safety assessment, pre-market safety assessment, or new data security requirements and obligations which have been introduced for online marketplaces, which reflect the changes to how technology products are sold and how they're used in the market. But there are also a raft of changes that affect most consumer products, not just emerging technologies. So, for example, GPSR introduces a new general accident reporting obligation for the first time in the consumer products sector in Europe. And it also establishes new requirements for recalls, including how you have to advertise a recall, how you can describe an issue, including certain prohibited language, what remedies you must offer where you're carrying out a recall, with a new minimum offering of at least 2 remedies, including repair, replacement, and refund. So you can see that its impact goes much wider than just new technologies, and has a sort of significant outcome for many manufacturing companies. I also wanted to mention the Product Liability Directive. Again, this is a sort of landmark reform. It's the first reform of this regime in nearly 40 years. It's very exciting for products practitioners like me. And by way of background, the EU has this strict liability, pretty claimant-friendly product liability regime under statute, which means that consumers can recover for damage without having to show that the producer was at fault. You just need to show defects, damage, and a causal link between the defect in the product and the damage suffered. So it's a fairly claimant-friendly regime. It was reviewed a few years ago by the Commission, and it was determined that certain updates were required, tweaks and clarifications in light of new technologies. So that's what the remit was. What we actually have seen are some changes responsive to that remit. So the definition of product has been expanded to cover not just hardware products, but also software, AI, and certain related services. There's a broader concept of defect, which will cover new issues such as cybersecurity risks, connectivity risks, software updates. And when it comes to software updates, it's worth noting that covered are not only the rollout of software updates, but also a lack of software updates. So a product can be defective because a producer failed to issue a software update, which is quite a significant change. When it comes to damages, those too have been tweaked to cover data loss and also certain types of medically recognized psychological harm. For data loss, something we certainly submitted was not required when it came to expanding the scope, because there's significant overlap with private rights of action under the EU's existing GDPR regime. And when it comes to psychological harm, there are concerns about what that means amongst many practitioners like me, whether that means that some types of the sort of broader scope of medically recognized psychological harm, issues like anxiety, could be recoverable, and if so, how widely that could sort of open up potential for claims in the digital context. But notwithstanding that the remit was very much focused on new technologies, the revisions don't stop there. Once the legislators had the opportunity to revise the regime, they really went to town, and we see a number of broader changes that are not specifically prompted by new technologies. So, for example, there's a new disclosure or discovery power. There's a broad-ranging power for courts in Europe to order disclosure of technical documents. And that's pretty novel because in many EU markets, big markets like Germany, for example, there are currently very limited disclosure powers. Proceedings rely chiefly on expert evidence. And so this is the first time that these kinds of disclosure and discovery powers that we've seen in jurisdictions like the US and the UK will be appearing within proceedings. There are also changes meaning that in certain circumstances, defect can be assumed. That's really important because it means that the burden of establishing defect, which is the primary hurdle under the current regime, a current regime which is already quite claimant-friendly, can be reversed in certain circumstances. So a defendant will have to prove that their product was not in fact effective. And most importantly, I think in the context of what we're talking about today, one of those circumstances is where there's a non-compliance with relevant EU regulations. So that really puts the onus on getting it right from a product compliance perspective on the front end to help mitigate your risks of liability down the track. One other circumstance, maybe just worth mentioning quickly, in which that sort of burden can also be reversed, is that defect can be assumed for products that are scientifically or technically complex. The idea there was that consumers can face a more significant burden to make out their case in circumstances where there are complex products. But the Commission has taken a position, and the recitals now reflect that that would include anything incorporating AI technologies. So that's pretty significant. Similarly, actually, also for medical devices, they've sort of taken the position that blanket that should apply to medical device claims. To me, that seems very broad and means that there there could be a very significant increase in claims in the context of those types of products, which is problematic in the context of AI because just the way the market is moving and the technology is moving, we're obviously seeing a significant majority of consumer electronics in the pipeline coming to market with AI integrated into them. And finally, there's an expansion in the range of defendants as well. So, for example, online marketplaces can be targeted under the Product Liability Directive for the first time. And just a word on timing before I move on, those new rules will begin to apply just before the end of 2026. Okay, so moving on from the sort of developments around new technologies, I also wanted to mention sustainability and right to repair, which remains very much a focus area in the EU. And this sits closely alongside the growth of the ESG regulations, which Jack, I know, will speak about shortly. So there's a whole suite of reforms in this space, including those identified on this slide. And taken together, the aim is to fundamentally change consumer and business behaviors in Europe, moving away from what has traditionally been seen as a sort of throwaway culture to a culture where products are used for longer, repaired in market, and then recycled at end of life more effectively. And with the time available, I was just going to pick up on a couple of initiatives I think are of particular interest. So the first of those is the EU batteries regulation, which represents a major challenge to how batteries and products containing batteries are going to be regulated in the EU going forward. I'm sure you'll be aware that this is a piece of legislation that's received a lot of attention. The focus of that attention has largely been on new requirements relating to the design, composition and labelling of batteries. Most importantly, in that regard, new requirements to ensure that batteries and products containing batteries have a removability and replaceability function. That is, if you sell a product that contains a battery, that battery needs to be easily removable and replaceable by the end user, not a professional, during the lifetime of the product. And that's an obligation that will apply from 2027. I think it's hard to overstate the impact of this new requirement because it will necessitate design changes to nearly every consumer electronic on the market, incorporating a battery. And it's proved a huge headache for lots of companies. There are usually very good reasons why you don't want consumers sort of poking around in the internal workings of an electronic device, carrying out their own repairs and replacements. And of course, there's a trade-off where you redesign a device to allow a consumer to replace the battery, which can mean, for example, heavier devices, a loss of waterproofing in many cases, and in most cases, a deterioration in battery performance. So that can, of course, vary depending on the device, but in some cases, we're looking at a drop in battery performance of about 20% as a trade-off to allow batteries to be easily removable and replaceable by end users. So those are requirements that are keeping members of our team very busy, or have been for the last couple of years, advising stakeholders on how they can try to comply with those requirements. And what I think has received a bit less airtime within the realm of the batteries regulation is that alongside these new design obligations, EU batteries regulation also introduces a suite of new EPR-like obligations. And those obligations have been in the spotlight this morning in the context of a series of Commission announcements today. So I will leave Jack to bring you up to speed on those in the context of his update on ESG regulation. Just before I move on from this slide, I also wanted to mention the EU Right to Repair Directive, which will apply from July next year. And the Right to Repair Directive is designed to facilitate right to repair in Europe and increase the number of repairs that are carried out in the EU. There are two main mechanisms under the directive. First of all, there's a mechanism to incentivize EU consumers to choose same device repair rather than replacement when they exercise their statutory warranty rights against retailers under existing legislation in the circumstances of a faulty product. And it does that by, first of all, obliging all retailers to explicitly inform consumers that they have a right to same device repair. And secondly, it will reward consumers who opt for repair by extending their statutory warranty period by at least 1 year if they opt for repair instead of replacement. Secondly, the Right to Repair Directive will also introduce a new obligation for manufacturers to carry out same device repairs outside the statutory warranty regime, which applies against retailers. That obligation will only apply to certain products at launch of Right to Repair provisions, products that include white goods, mobile phones and tablets, amongst others. There's an annex within the directive that lists out all of the products subject to those obligations. One thing worth bearing in mind, if you have this on your radar and have already checked and think you're out of scope of that, is that the Commission has powers to add more products over time. There are already 2 pieces of delegated legislation on foot which will do that, including to products like certain types of electronics, ICT equipment. There is an expectation and indeed a likelihood that various products will be brought into scope of those powers in the future. So that's something that should be very much on your radar for monitoring to ensure you're aware when your product inventory might be caught by those obligations. Okay, I think that's enough on sustainability and right to repair. Mindful of time, I just wanted to say a few quick words about the digitalization of compliance enforcement. I wanted to say a bit about this because there's a lot of focus at the moment about how reforms to digitalize, including under the Omnibus initiative, which will be on a lot of your radars, I know, could sort of cut red tape, reduce documentation, labeling and packaging obligations, with obvious benefits for consumers, businesses and the environment. Probably the most high-profile sort of initiative in that space being the digital product passport. But there is an ancillary to all of this, which is probably less talked about, and that's that the EU has some of the most stringent product compliance regulations in the world. We've seen the slides that show the volume of new regulation that's come in, but enforcement is an area that's traditionally lagged behind the sort of ambition of new regulation. And a lot of that is driven by a lack of resources at member state authority level and at EU level to police compliance with these regulations. So the EU is also taking steps to harness digitalization to increase enforcement. So it's not just a tool for reducing paperwork, it's also a tool for increasing compliance. And to do that, the EU is pushing for digitalization of product compliance information, for example, in the Digital Product Passport initiative I mentioned, so that there are databases of compliance information that can be reviewed digitally. And at the same time, the EU is also investing significantly in new AI systems under its customs reform plans to more effectively block import of non-compliant goods into the EU. And those new checks will primarily be targeted at direct and online sales. So the intended effect of this sort of digitalization of enforcement is to sort of plug that gap we've seen historically, so that there'll be much more robust product compliance enforcement in the future. Okay, that was the last thing I wanted to mention. So I will hand over next to Jamie, who's going to say a word, I think, on a UK update.
Thanks, Ed. So as we've heard, there's a huge amount going on in the EU, but we just wanted to briefly touch on a couple of UK initiatives. Since Brexit, there's been a period of passive divergence as the EU's been moving ahead with all the changes we've been discussing, but the UK hasn't been focusing on making changes to the products regime. But now we're starting to see those changes come in. So first up is the Product Regulation and Metrology Bill, so the PRAM Bill, and that was introduced into Parliament last September, and it was introduced as an enabling bill. And what that means is that it doesn't say very much, but it grants the UK's product safety regulator, the OPSS, the powers to make product safety rules without returning to Parliament. Now, understandably, Parliament wasn't very happy about that, and so recently the OPSS has published a code of conduct that introduces checks and balances on how product safety rules would be introduced, along with promises to consult on certain changes. There are also powers being granted to allow the UK government to follow or to diverge from the EU laws to avoid this current state of passive divergence that we've been seeing. With the current government, our expectation is that we'll see more alignment rather than less, given the strengthening relationship between the UK and the EU. We are expecting the bill to come into law by this summer, with the detailed regulations to follow later in the year. We don't yet have full visibility on what those regulations will say, but we understand there'll be some sort of key changes based on historic consultations and statements by OPSS. So that will include something around online marketplaces, which have been a real focus of OPSS. We're expecting to see updated rules there, in particular in placing additional responsibilities on certain online marketplaces for the safety of products sold via their sites. E-bikes and coin cell batteries have been a key focus of OPSS over the years, so it wouldn't be a surprise to see new rules there. The common charges regime in the EU, which has been effective at harmonising cable charger standards for electronic devices by mandating the USB-C standard. The OPSS have indicated that they're willing to adopt those rules, so we may see those come into force as well. And also, it wouldn't be a surprise to see the accident reporting regime that the EU's adopted under the GPSR also come into force as well. The OPSS has always been very keen to gather more data around product safety, and that is one way that they can do that. I think one of the areas that we don't think it will cover is the sort of product liability regime, but it won't be surprising if we do see some changes to that in the future. Next up is the Digital Markets Competition and Consumer Bill. Now that's a really significant piece of legislation covering competition and consumer issues. Just wanted to quickly touch on some of the implications from a consumer perspective today. And it's a really sort of focus on tightening up around online sales. So some of the key changes are a crackdown on drip pricing, so new requirements to exhibit the total costs upfront in adverts and online product listings, rather than allow additional costs and charges to be added as you go through the process of purchasing a product. New rules around fake reviews. So they'll be aimed at combating the fake reviews online and putting in place systems and processes to identify, investigate, report, respond, and remove fake or misleading reviews. Also rules around subscription contracts, so ensuring that there's sufficient pre-contract information, reminder notices, and exit routes and cooling off periods to avoid consumers getting kind of trapped in that subscription cycle. The CMA could also be imposing requirements on online platforms to prevent them from preferencing their own products and services ahead of those of competitors. And with the theme that we've been talking about throughout, there's also a sort of stronger enforcement piece here, where the CMA will be given powers to directly enforce the consumer protection laws through administrative proceedings without having to go to the courts first, and with also the potential to impose fines of up to 10% of annual global turnover. We are expecting to see some of the provisions around drip pricing and fake reviews in consumer protection already being enforced. So that's from the 6th of April this year. And then the subscription contracts regime will apply from next spring, 2026. And with that sort of whistle-stop tour, I'm going to hand over to Jack to talk through the latest developments in ESG.
Great, thanks, Jamie. So sustainability is one of the legislative areas where the EU has really been driving ahead, largely developed under the last commission. These requirements, we're really now seeing them starting to come into force as their transition periods come to an end. So we're going to dive straight in, as we have rather a lot to cover in the time that we've got left. We're going to start with the EUDR. or the deforestation regulation. And now this is a good one to start with, both because of the impending compliance deadline and because of the legislative journey up to this point, with last-minute delays and simplification guidance just being published, something that you will see is currently a bit of a theme under the current commission. So what is the deforestation regulations? So these came into force in June 2023, and following kind of last-minute delays, the application date is now the 30th of December 2025, with slightly longer transition periods for smaller companies. Under the EUDR, for those that aren't very familiar with this legislation, businesses will be prohibited from importing or making available on the EU market or exporting certain products from the EU unless those products are deforestation free, have been produced in accordance with local laws, and are most importantly covered by a due diligence statement. And the kind of key pinch point here has been for companies preparing for this legislation that this due diligence statement needs to be provided before the product can be made available on the EU market. And importantly, there's no de minimis amount. The kind of list of products covered by the EUDR is narrow, so a product is in scope if it is covered by one of the customs codes listed at the back of the regulation, and it's any product that has been made using or fed with or containing a set of raw commodities, kind of cattle, cocoa, coffee, oil palm, rubber, soy, and wood. So you need to look at the back of the regulation to work out if your product is in scope. If it is, this due diligence statement that you need to file needs to contain quite a lot of information, including information identifying the country of production and the geolocation of the plots of land where the relevant in-scope products were produced. Importantly, by submitting these statements, companies will also be required to confirm that they have carried out due diligence and that no or only a negligible risk was found that the product does not comply with the EUDR. So this is important because breach of the EUDR with at least serious negligence can be a criminal offence, carrying up to 5 years in jail. There are kind of two updates there to kind of flag to your attention. Firstly, there have been recent leaks on the kind of country risk classification. Why is that important? Well, what level of due diligence is required under the EUDR depends on where your company is in the supply chain, the size of your company, and critically, the risk classification of your source country. The final list is due to be published on the 30th of June this year, but kind of probably good for business. It's rumored that the kind of low risk countries is expected to include all EU member states and is likely to include the US and maybe also China. So products originating from these low risk regions will benefit from a simplified due diligence process, which will not require an in-depth risk assessment or the adoption of risk mitigation measures. You will still, however, need to collect some of the supply chain traceability information, such as the geolocation of the place of production. Second, and much more concrete, because we now have published new guidance and new FAQs, are the recent Commission steps to simplify the EUDR obligations somewhat. Recent useful clarifications include things like packaging being exempt unless the packaging is placed on the EU market in its own right, and probably most significantly, simplification measures introduced benefiting downstream businesses such as retailers. So those that aren't importing kind of products under the EUDR, for those that are just selling on, it will be sufficient for these downstream companies to collect and reference the due diligence statement reference numbers obtained from those upstream in order to satisfy their own obligations. Before we move on from the EUDR, I just want to flag that there is a UK equivalent, but we are still waiting for implementing legislation to bring it into application, and there isn't obviously any significant movement there. So for now, the UK doesn't have an equivalent regime. turning to the ESPR, or the Eco Design for Sustainable Product Regulation. Now, this entered into force in July last year. The ESPR is what we call a framework piece of legislation. It establishes a framework for the setting of eco-design requirements that products have to comply with. Eco-design requirements have been around for some time, but have focused on energy efficiency and have kind of really applied to a narrow range of products, mostly white goods and electronics. However, under this new ESPR regime, the EU is expanding the scope beyond energy-related products to any physical goods that are placed on the EU market or put into service, including components and intermediate products such as steel and aluminium. So the ESPR scope is very broad, and it doesn't differentiate between B2B and B2C, except in limited circumstances. There are a few exemptions for foodstuff, medicinal products, veterinary products, but these are pretty narrow. So as it stands, because it's a framework piece of legislation, the ESPR does not actually contain many obligations specific to products. Instead, delegated legislation will be drafted for each product group, specifying what eco-design requirements apply. So the two updates here that we really wanted to flag to you is firstly that the Commission recently published its working plan, setting out which products are going to be the first to be regulated under this new eco-design for sustainable products regulation. These include things like steel, iron, textiles, but interestingly, chemicals and footwear haven't been left out for now. You'll see that electronic equipment is not currently listed on the slide, but I just wanted to flag that there are horizontal requirements that are also planned in the kind of next 5 years, which will be setting requirements on repairability and recycled content for those products. What can we expect from this product group specific legislation? Well, this will be a combination of performance requirements and information requirements. And it's these information requirements which will then be fed into the digital product passport. We won't go into detail of what these kind of performance requirements will look like, but I just got it here on a slide for your reference further down the line. The second thing to be aware of under the ESPR is that while we're waiting on delegated acts, there are some looming deadlines to be aware of. The key one here that I want to flag is the annual disclosure obligations, which are starting to apply to companies' first full financial year, starting on or after July the 18th. 2024. So lots of clients have already been preparing for this. We still don't have clarity as to what these final disclosures look like, but lots of people are being caught out by not having gathered this information. A real quick touch on the packaging and packaging waste regulation, which entered into force much more recently in February this year. This replaces an existing directive and is meant to facilitate greater harmonization in an area that has typically seen really significant fragmentation across the EU. These obligations are phased in from August 2026. The key thing to note here is that this packaging and packaging waste regulation is much broader than the UK's new extended producer responsibility regime for packaging, which started to apply in January this year. It introduces new sustainability design requirements, new labeling requirements, and various anti-greenwashing measures. Now, conscious of time, I'm going to skip over details on these, because what we really want to get to is kind of the overview and a quick update on the omnibus. So what's hopefully clear from this kind of whistle-stop tour is that there are kind of some key themes. One, businesses will be increasingly required to map their supply chains to source, whether to identify specific high-risk commodities or to be able to report the material content of their products and packaging. Two, product manufacturers need to increasingly take into account sustainability considerations at the design stage of their products. Three, there is growing emphasis on the need for businesses to take greater responsibility for the impacts of their business models, whether that is the upstream impacts on the environment and local communities connected to the materials that they source, or the downstream impacts of the products they use. kind of the many heads of this sustainability drive is encapsulated by the batteries regulation. Kind of as Ed already touched on, there are various sustainability design requirements to ensure replaceability and kind of fit the kind of battery related products within a circular economy. But there are also significant obligations regarding the need to conduct due diligence on battery materials, requiring companies to adopt due diligence policies and risk management procedures to identify, assess, and address adverse human rights and environmental impacts in the early parts of their battery supply chain. And having these policies in place, they also need to be verified by a third-party notified body. Before I turn to the Commission's simplification drive, there is a significant update here. This slide is, as of today, potentially slightly out of date. The Commission published today a proposal to delay the due diligence requirements under the batteries regulation by 2 years. So if there is political agreement, this August 2025 compliance date on here will become an August 2027 compliance date. Finally, and sorry, it has been very quick, the omnibus, or rather I should say the omnibuses, because there have been rather a few. As part of the EU's competitiveness compass, there has been a broader drive to simplify legislation. At least simplification is the purported aim, but the last minute approach has unfortunately created greater business uncertainty and often wasted costs. While the kind of sustainability-focused omnibus has dominated commentary, there are a few other omnibuses that we wanted to flag for your put on your radar today because they were released earlier this morning. So that is one, the introduction of a small mid-cap category of companies that, if adopted, will have implications for derogations under various pieces of legislation up until now reserved for SMEs. And the second is one focused on digitization. We're still very much working through these, but a few key things to highlight is firstly, this small mid-cap omnibus impacts 8 pieces of different legislation, including the GDPR and the batteries regulation. So for the batteries regulation, they're thinking about moving the financial threshold for due diligence obligations up from 40 million EU turnover to 150 million EU turnover. On the digitization side, that's likely to have a far greater impact for product manufacturers. If it is adopted as drafted, it will require changes to labeling, including on-product labels, to include digital contact information for the manufacturer and importer. Importantly, it would also require new on-product markings where instructions are provided digitally, explaining how consumers can access those digital instructions. Safety instructions, on the other hand, look like they will still need to be in paper form. The information on the slide kind of pertains to the sustainability omnibus, but given the volume of information that's out there on this, I think we will keep it very brief, just to flag that the stop the clock, the delay to the reporting and due diligence obligations is now law, but the substantive changes are very much still up for debate and are expected to be hotly negotiated. So we're not expecting any clear guidance there as to direction until at least the end of this year, if not early next. And with that, I will stop there to answer a few questions.
Brilliant. Thank you so much, Jack, and also to Ed and Jamie as well for that really comprehensive outlook onto the whistle-stop tour, as you call it, of the EU and UK product compliance landscape. I am very conscious of the time, and I think it's indicative of the amount of change that have happened that we've run up against the clock. So there's been a lot of questions that have come in, and we'll definitely follow up with everyone who submitted a question. And if there's any more questions that you have, please do use the Ask a Question widget right now. But I will hold questions just to be conscious of time. I don't want to run over, and we'll follow up with everyone directly after the webinar. So with that, I want to thank everyone so much for tuning in with us today and hope you've found it helpful. We look forward to seeing you in our upcoming webinars. You can check out our resources section on the website to stay updated and to access our latest white papers, blogs, upcoming webinars, and also webinars on demand. And as I mentioned, this webinar will be made available on demand, and you'll get the recording within 24 hours. And yes, I can just see out the Q&A. The full Q&A list will be made available to everyone. I'll share it with everyone once all the questions have been answered. So you'll all get access to that. I can see a few people here asking about it. Thank you so much to Ed, Jack, and Jamie for your contributions. It's been fantastic. And we have plenty of upcoming content, so make sure you keep an eye out. Our next webinar, Asia's ESG and Sustainability Landscape, Compliance Essentials for 2025, is scheduled for June 4th. So we hope to see you there. Thanks again.